For treaty relations, this is Michael Webster, Aishat Nyola, and Megan Turcotte's presentation on the St. Catharines Milling and Lumber v. the Queen. Our first slide is going to be a few minutes of a YouTube video that we found online that was made by a student who is presenting on a similar topic. There is no audio to this video. Instead, it's merely a graphical depiction of the case made using Microsoft Paint. The case of St. Catharines Milling and Lumber is one of the prominent cases on Indigenous law and also on the divisions of power between the federal and provincial governments in Canada. The inciting factor of this case was Treaty Number 3, which was a treaty signed by Ojibwe peoples in Northwest Ontario, or in the Wabigoon area of Ontario, near Thunder Bay. This treaty comprised of about 50,000 square kilometers of ceded lands, 32,000 of which, for the purpose of this presentation, we'll describe as the disputed lands, as these 32,000 square kilometers were within the boundaries of Ontario. St. Catharines Milling and Lumber was given a permit by the Dominion of Canada to cut approximately 1 million feet of lumber in the disputed lands. The province of Ontario disputed this, saying that they had complete control over the beneficial interests of the land, including the lumber thereon. They filed for an injunction and damages against St. Catharines Milling and Lumber and the Dominion of Canada to prevent them from cutting lumber and removing the lumber that had already been cut, as well as seeking damages for the cut lumber. This case was found in favor of the Ontario government at the trial level, as well as the appellate and the Judicial Committee of the Privy Council in England. While this case does impact Indigenous rights, particularly in regards to land, Indigenous peoples were not witnesses, parties, or even involved in any way during the proceedings of this case. Instead, it was litigation between the two levels of government in Canada.
The facts about the case. The full case name is St. Catharines Milling and Lumber Company versus the Queen. The court that was in charge of the case, like one of the court that was in charge of the case, is the Judicial Committee of Privy Council. The case was decided on December 12, 1888. The St. Catharines Milling case was the most prominent case on the Aboriginals for more than 80 years in Canada. The St. Catharines Milling and Lumber case was a company that received a permit from the Dominion government to log into the Wabigoon Lake area of Ontario. The First Nation in the area, various Ojibwe, were signatories to Treaty 3 with Canada.
This case is a leading decision in Canada on the differences between the division of legislative powers and property rights between the federal and provincial governments under the Constitution of Canada. The Judicial Committee of the Privy Council said that Indian title to land is a personal and usufructory right dependent on the goodwill of the sovereign, who holds paramount estate to the land, upon which Indian title is a mere burden. The Privy Council ruled on whether the Dominion government or the provincial government held the title to lands surrendered under these treaties, particularly the disputed territories which were within the geographical boundaries of Ontario. The treaty in this case, Treaty Number 3, had never previously been litigated before in any court. The Dominion government had issued a license to St. Catharines Milling and Lumber with the justification that they had jurisdiction over the lands because of past and continuing Indian interests and the costs that the Dominion government had incurred in guarding those interests. The provincial government, on the other hand, argued that the estate held by the Crown prior to the ceding of the lands passed to the provinces and not the Dominion, pursuant to Section 109 of the British North America Act.
The situations. All ungranted lands in the province belong to the provincial crown, subject only to Indian right of occupancy. As such, St. Catharines Island is held by the province of Ontario. Once the Aboriginal rights are extinguished by treaties, then the land no longer falls under the federal jurisdiction as land for Indians. Therefore, St. Catharines Island is held for the province of Ontario.
The important issues of the St. Catharines Milling case. This case attempted to clarify the nature of title held by the Dominion of Canada and the provinces in respect to lands ceded through treaties with Indigenous peoples. It was initially assumed, or it is assumed, that the British Crown had title and sovereignty over the traditional territory of the Aboriginal peoples, even before the actual treaty was signed. The main legislation relied upon in this case was the BNA Act of 1867, particularly Section 91, subsection 24, which vests the power of legislation for Indians and lands reserved for Indians with the Dominion government, and Section 109, which states that the provinces have the entire beneficial interests of Crown land within its boundaries, including lumber rights. Another important piece of legislation to this case is the Royal Proclamation of 1763, which was considered to be the constitution of Indigenous peoples in Canada. And in this case, it is proposed to be the source of Indigenous title.
The case outcome. The Treaty Number 3 ceded the whole rights and the title of the land in question to the Crown, therefore making it its Crown land. The pursuant to Section 109 of the British North American Act, which stipulates that the provincial legislation has the beneficial interest of Crown lands within its boundaries. In this case, approximately 32,000 square miles. Therefore, by virtue of the beneficial interest in the land held by the province, the permit for the felling of trees in the disputed lands given to the St. Catharines Milling by the Dominion of Canada was held to be invalid.
Impacts of the case. Several legal principles were solidified during the case of St. Catharines Milling and Lumber v. the Queen. The first of this is the establishment of Indian title as a personal and usufructory right, which is a mere burden on the Crown title to land. This case, while the personal and usufructory section of that is no longer valid, and Aboriginal title is now considered to be a proprietary interest in the land, it is still maintained that Aboriginal title is a burden on the underlying estate of the Crown to the land. Another impact of the case was the principle that Indian rights were not common law rights, are not inherent rights, but were instead based on the Royal Proclamation of 1763. And therefore, Indian title was contingent on recognition from either the legislative, the executive, or the Constitution. Now it is considered that Aboriginal title is an inherent right which exists regardless of whether or not Canada exists. Another major impact of the case was the principle that Indian title was dependent on the goodwill of the sovereign, which was then taken to mean that Indian title could be unilaterally extinguished by the executive without legislative authority. This principle was reliant on Indian title being non-proprietary, and since it has been later found to be a proprietary interest in the land, although being a unique one, this principle is no longer a valid piece of Canadian law. To dive a bit deeper into the nature of Aboriginal title being a burden on the Crown's underlying title, the Crown title is described as being a substantial and paramount estate, which underlies any existing Aboriginal title. To quote from Tilscotton case, at the time of assertion of European sovereignty, the Crown acquired radical or underlying title to all land in the province. This Crown title, however, was burdened by the pre-existing legal rights of Aboriginal people who occupied and used the land prior to European arrival. In other words, the Crown has title to all land in Canada by virtue of having asserted sovereignty over it. In other words, this is a case of might makes right, in that the government of Canada owns Canada because they say they own Canada. Thank you for listening to our presentation. We hope you enjoyed it, and thank you for your time.